Leader, third party.
Well, thank you, Honourable Speaker. I had thought that there was a much longer speaking list and that I would be speaking subsequent to other speakers, but I do thank you for recognizing me. I arise to speak in favour of the bill before us. That is, if you bear with me for a second, that is Bill 11, let me get all my International Commercial Arbitration Amendment Act 2018. As has been mentioned, this is an important piece of legislation that modernizes our existing International Commercial Arbitration Act, taking into account the changes that were done by the United Nations Commission on International Trade in 2006 in their updates to model legislation there. This comes on the recent move that Ontario did to update its act in March of 2017, where they did something very similar in a very similar tape to modernize the original 1985 model law that was adopted by BC. We're one of the first to do so, frankly, as well as other jurisdictions. It's clear that as well that this is not something that was dreamt up overnight, that obviously there has been some good work that was done into this over many years, and so it's important to credit both sides of this House for the work that they've done to bring this to fruition, to ensure that we actually bring our arbitration law up to international standards, taking into account the best practices that exist as outlined in the United Nations Commission on International Trade model law. So, as the government has noted, the government has suggested that they have a responsibility, and I agree, to ensure that standards are modern, that meet the standards of the bar and judiciary, and that confidence and that these standards have the confidence of international and domestic clients, and this is one of the goals of modernizing our present legislation. In addition, virtually all provinces and territories in Canada have incorporated the UNCITRAL. Sorry, I'll say it again. It's the United Nations Commission on International Trade Law, the UNCITRAL model law of 1985, into their respective statutes, and each province or territory has a separate piece of legislation that deals typically with domestic or international commercial arbitrations. And in fact, all Canadian provinces and territories as well, with the exception of Quebec, have adopted and ratified the New York Convention, allowing for the recognition and enforcement of arbitral awards from its signatory states, of which Canada and British Columbia are. Ontario was in fact the first Canadian jurisdiction to amend its legislation to reflect the changes made to the model law in 2006, and as I noted, this was done in March of 2017 last year, and BC was setting the stage to do that. Of course, we had something rather irritating occur between March and May of last year, irritating for some, but delightful for others. We had an election, and that would have clearly have ensured that there was these sort of pieces of legislation that take time to develop. Obviously, the civil service had been working hard on this in consultation with stakeholders as well as government, and this piece of legislation has smoothly passed through the transition from former government to the present government, and is brought here today for our debate and presumably adoption based on the comments I've heard from both sides of this House. Honourable Speaker, federally international commercial arbitration is governed by the Commercial Arbitration Act, and this deals with things like investor-state disputes brought under NAFTA or CETA and similar agreements. NAFTA, of course, is the subject of much debate as we speak here in this legislature due to negotiations happening with our federal government, Mexico, and the United States. As quoted by some, I'd like to provide a quote here from an individual. I'd like to get the exact. It's the International Arbitration Review, Edition 8, Canada, by Gordon Tarnowski, QC, and Rachel Howie, Chloe A. Schneider, and Holly Cunliffe, published in the Law Reviews of August 2017. They say this: although similar in many respects, there are certain marked differences in international commercial arbitration legislation among Canadian jurisdictions. This situation can create unforeseen risk to interjurisdictional entities that might ultimately resort to arbitration in more than one jurisdiction, or to those choosing a city in Canada as a seat of arbitration if they are not fully aware of the variations. This is one of the reasons why, Honourable Speaker, it's critical for us to adopt legislation along the lines we have here to modernize and bring to standards that are adopted by the United Nations, our arbitration laws here, both nationally and federally. You know, Australia did some recent work in this regard, and prior to 2010, domestic legislation regarding arbitration varied between each and all of the various different states in Australia, but the model commercial arbitration bill that they agreed upon by the standing committee there of the General Attorney Generals actually was the way of creating domestic arbitration law throughout Australia that was uniform, and they've all since adopted that, and we're hoping to see such things happen here in Canada as well. You know, there's a couple of benefits of adopting this law. Not only is it important to have Vancouver become a host for arbitration, international arbitration. It's one of the selling cards of Vancouver. A government led by Premier Gordon Campbell did a very fine job of actually bringing British Columbia to its pinnacle of international recognition as a go-to destination in the world, culminating in the 2010 Winter Olympics. Prior to that, of course, we have to give due respect to Bill Bennett, who recognized he was probably the first who really went beyond the parochial vision of British Columbia as only a province of Canada, with bringing in Expo 86, I believe it was. I was in Vancouver living there at the time at UBC, and that too put British Columbia on the international arena as a go-to destination. 2010 Winter Olympics, another critical aspect in this regard. And Vancouver has grown. This is very much a bill that's focused on Vancouver, Honourable Speaker. But Vancouver has grown to become an international city, one that unfortunately has byproducts associated with that happening, one of which is, of course, the affordability crisis that's affecting Vancouver. But nevertheless, this is actually good for business, Honourable Speaker, this bill. This bill is good for business and for sending business the exact type of signal that they need to say, that British Columbia is open for business, it's open for international business, and it's a go-to destination if you want to actually have business in the new economy. I'm excited by the prospects of this emerging economy that's happening here in British Columbia. I'm less excited by the trials and tribulations of members opposite as they sulk and complain about Kinder Morgan and others, but there are so many opportunities in British Columbia, and adopting legislation like this, a legislation that modernizes our arbitration proceedings and that actually positions Vancouver as a leader, a go-to destination in the world, along with places like Paris and New York, to come and actually have arbitration cases settled in a means and ways, in a very nonpartisan way, in a manner, in a way that's viewed to not have any particular biases. We have a good brand internationally, Canada, in terms of brokers of deals and being fair-minded, and Vancouver, British Columbia, can lead in that regard. But it does have that other very important signal that it's sending. That Vancouver, British Columbia, we want to be a focal point for international business, and we want companies to come here. We want companies like Tesla to come here. We'd love it in British Columbia if Tesla came to BC and built a gigafactory in Terrace to ship those batteries to Chicago or Prince Rupert via the railway that exists. We'd love companies to actually build in terms of the innovation potential that we can offer here. This is the direction we're going. This piece of legislation is critical to continue our path towards to building Vancouver as an international hub for excellence, and British Columbia in general, with all its communities from north to south, east to west, rural to urban, suburban to single cabins on the lake. We're excited about the prospects for British Columbia. Honourable Speaker, another benefit of this bill, of course, is that there is coming forward relatively soon, is we're going to find I believe it is in 2022, that Vancouver's bidding to host the International United Nations Conference. My notes here don't actually have the date. Well, they do somewhere, but they're buried within my multiple pages of notes. But in this international conference, which is coming to Vancouver, it's kind of hard as part of your bid to put a bid in to host the international conference, UN conference on arbitration, and then at the same time not be, brought yourself up to standards that since 1985 recognize that in fact we have the preponderance of technology that exists today that didn't exist then, and many other such examples. With that, Honourable Speaker, I say after speaking with both my colleagues from Saanich North and the Island, as well as my colleague from Cowichan Valley, we're in support of this bill and look forward to committee stage and supporting the bill through to final adoption in this legislature. Thank you.